Emphasizing that economic policies cannot take away the people's choice, the Supreme Court in a verdict has ruled that all private properties cannot be considered material resources of the community under Article 39B of the Constitution, and consequently, these cannot be taken over by the state in interests of the common good. Today, the court came out with 3 different judgments on the topic. In May, a 9-judge bench had reserved its judgment in the case, and the same is being pronounced now. The first judgment was delivered by CJI Chandrachud along with 6 other judges who agreed with him, including Justices J.B. Pardiwala, Manoj Mishra, Rajesh Bindal, S.C. Sharma, and A.G. Massey. Meanwhile, Justice B.V. Nagaratna disagreed with the majority view on the point of Article 39B, while partially agreeing to the decision. On the other hand, Justice Himanshu Dhulia dissented altogether. But first, let us find out what Article 39B says. Article 39B is part of the Directive Principles of State Policy, which are dealt with in Part 4 of the Constitution. These principles are fundamental to the governance of India and are intended to ensure social and economic justice for all citizens. But they are not justiciable, that is, enforceable in courts, and are yet considered to be the basis for the government's policy formulation. Article 39B of the Constitution states that the state shall in particular direct its policy towards securing that the ownership and control of the material resources of a community are so distributed as best to subserve the common good. Simply put, this provision places an obligation on the state to create a policy towards securing the control and ownership of the community's material resources for redistributing them for the common good. So, the judgment delivered interpreted the crucial words material resources. In the 1977 ruling of the Supreme Court in State of Karnataka versus Sri Ranganatha Reddy, a 7-judge bench had attempted to interpret these words. Back then, Justice Krishna Iyer had said that everything of value or use in the material world is a material resource, and since the individual is a member of the community, his resources would also form a part of it. Justice Iyer's minority opinion was in fact upheld by a 5-judge bench in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal in 1982. The majority verdict held that some, not all private properties would constitute material resources, and that Justice Iyer's earlier opinion was motivated by a particular economic and socialist ideology of the past. However, Justice Dhulia, in his dissent, upheld Justice Krishna Iyer's view, saying, what privately owned resources fall under the definition of material resources is not for the court to decide, but instead a matter for the legislature or the parliament to determine. The judgment was delivered in a case that stemmed from a challenge made by property owners to the Maharashtra Housing and Area Development Act, following an amendment in 1986. A new chapter was inserted in the Act in 1986, which allowed for the acquisition of properties by the state for restoration or preservation purposes. This takeover, however, was subject to the state paying 100 times the monthly rent of a property if 70% of the building's owners or occupiers made an application for the same. The new chapter also declared that the amendments in the housing law intended to give effect to Article 39B of the Constitution, which, as we discussed earlier, allows the state to make policies for controlling, owning, and redistributing a community's material resources for the public good. Now, this new addition to the law compelled the property owners who owned the buildings in Mumbai to move the court and challenge this provision on grounds that it violated their right to equality. On the other hand, the Maharashtra government had contended that run-down buildings can be taken over by the state and redistributed for the public good. From the Bombay High Court, where it was initially dismissed by a two-judge bench, the case made its way to the Supreme Court's three-judge bench, which in 1996 ruled that since the decisions in Minerva Mills and Sanjeev Coke were all delivered by a bench of 5 judges and that it was indisputed that Article 31C was still in force, it would be appropriate to refer the matter. This 5-judge bench in 2001 reiterated that the interpretation of Article 39B requires reconsideration. Following this, the case went before a 7-judge bench, which in 2002 remarked that there was some difficulty in sharing the broad view that material resources owned by the community include privately owned resources. But few know that this moot point was born out of the conflicting opinions given by 2 judges in state of Karnataka versus Sri Ranganatha Reddy, where Justice Krishna Iyer had given a minority opinion that a community's material resources include both private and publicly owned resources, while Justice N.L. Untwalia had disagreed with this. In Tuesday's ruling, Justices Nagaratna and Dhulia disagreed with the majority's criticism of Justice Iyer's opinion. While Nagaratna reportedly said that Justice Iyer's reasoning had come in the context of the socialist, constitutional and economic architecture of those times where the state had a fundamental role to play, Justice Dhulia said that the broad and inclusive meaning given to the expression material resources by Justice Krishna Iyer has lost none of its relevance or jurisprudential value, nor has it lost the audience which appreciates these values. As for the validity of the Maharashtra housing law, the bench referred the matter to the Chief Justice to place it before an appropriate bench so that the issues arising in it can be determined on the basis of the principles underlined. And with that, it's a wrap. This is Khadija Khan from New Delhi. For more legal updates, keep watching The Print.